When ungodly individuals enter an arena, their values enter with them. After decades of the extraction of godly individuals, and thus godly principles from public affairs, the change in philosophy became apparent in our national leaders, especially at the U.S. Supreme Court. Consider, for example, the issue of school prayer and the public acknowledgement of God. School prayer had been practiced in America's public schools for 300-plus years, and it had been constitutional for 171 consecutive years under the Constitution. Why? Because school prayer had been constitutional in the personal beliefs of the Founding Fathers and in the beliefs of subsequent justices sworn to uphold the Constitution. However, in the 1960s, a new group appeared on the court with a different set of personal values. They uncovered a statement which suited their beliefs, a misleading phrase found neither in the Constitution, the First Amendment, nor any other official founding document. That phrase? Separation of church and state. But under the new application of this phrase, in 1962, in the case Engel versus Vitale, school prayer was suddenly and without precedent ruled to be unconstitutional. Then the very next year, the court struck down another long-standing practice of public schools, a practice implemented by founding fathers like Benjamin Rush, Noah Webster, Samuel Adams, John Adams, Jedediah Morse, William Samuel Johnson, and Thomas Jefferson. What was that practice? The use of the Bible in schools. On what ground did the court remove the Bible? For the second time in 2 years, those justices cited neither history nor legal precedent. They invoked not one founding father nor one previous court decision. They did, however, invoke the aid of a psychologist, and following his testimony, the U.S. Supreme Court announced a reason why the Bible must now be taken out of schools, following nearly 2 centuries of its use in schools. What was that reason? The Supreme Court explained that if portions of the New Testament were read with that explanation, they could be and had been psychologically harmful to the student. The basis for the decision in the 1963 Bible reading case is evidence that a leader will always rule by what he personally believes to be correct. He cannot separate the public policy that he enacts from that which he personally believes. In the case Stone v. Graham, the court even ruled that it was unconstitutional for students at public school to see a posted copy of the Ten Commandments. This ruling was amazing, for a picture of Moses holding the Ten Commandments is actually etched in stone inside the Supreme Court. Furthermore, the Ten Commandments appear in numerous civic buildings, courthouses, and legislatures across the nation. Why is it that the Ten Commandments hang in so many civic, governmental buildings, yet hang in so few churches? It is because that for over 2,000 years in the Western world, the Ten Commandments have been recognized as the basis of civil law. From them we derive such things as don't murder, don't steal, don't perjure yourself. Why then did the court rule that students could not see the very laws which form the basis of our current civil laws? The court explained that if the posted copies of the Ten Commandments are to have any effect at all, it will be to induce the school children to read, meditate upon, perhaps to venerate and obey the commandments. This is not permissible.